So today we're here to talk about platform liability, which is an area of the law that Wigan is very much involved in. So Sinclaire, I suppose one of the first questions to ask is, what do we mean by platform in this context? And what can platforms be liable for?
So I think in common parlance, a platform might be a social media platform or an online marketplace. But when we're taking this legal perspective, we really want to hone in on the specific services that the platform is providing. And we also need to consider whether it is an information society service. Now, to define information society service, I'm going to need to pull my notes out because it's a bit of a mouthful. This basically means any service normally provided for remuneration at a distance by means of electronic equipment for the processing and storage of data and at the individual request of a recipient of a service. So what does that mean? Basically, it's quite broad and it could encompass anything from internet service provision to a search engine to those original social media platforms and online marketplaces we kind of started off with. So I think your next question is, what is really the risk for these platforms or services?
So it really depends on the nature of the service and the activities that it's undertaking. So from a copyright perspective, relevant factors that we'd be thinking about is whether the service is hosting content or whether it's transmitting or linking to content. And for trademarks, relevant factors could be whether the platform is itself selling goods under the trademark in question or whether it's fulfilling the customer orders. There are certainly circumstances where a platform can be liable for infringing intellectual property rights, but we also need to consider the safe harbours that exist under both EU and UK law and which can provide a safe harbour against liability.
Yeah, so of course we've got the e-commerce directive, which was implemented in the UK and the e-commerce regulations in 2002. And as you said, these provide a shield for liability for service providers in certain situations, so when they're acting as a mere conduit, caching, or hosting. And of course, this isn't limited to IP infringement, although that's our focus. It's probably also worth mentioning a separate regime that governs liability for online content sharing service providers, another mouthful, and that's governed by the 2019 copyright directive at the EU level, so not in the UK. But back to these safe harbors under the e-commerce directive. Based on your experience, what do you think the most important of these are?
Yeah, so I think the answer is they're all important. The mere conduit safe harbour will be relevant where the service provider is carrying content or whether it's temporarily storing content in its network. So it will be relevant to service providers that are acting as the pipes to the internet. I think the safe harbour that has probably been most debated is the hosting safe harbour. And so to fall within that exemption, the hosting provider's activities must be neutral. And so what we mean by that is the activities must be sort of merely technical, automatic and passive. As soon as the platform gets actual knowledge of infringing activities and content on its service, then it has to take expeditious steps to remove or disable access to the content if it's to stay within the confines of the safe harbour. And so it then becomes important as to what kinds of notice and takedown procedures the platform has in place and how it responds to takedown notices that are sent by rights holders. One other factor to consider is that certainly under EU case law, if a platform is found liable for communicating to the public, it doesn't then have the benefit of the hosting safe harbour.
So on the topic of notice and takedown, I think that's been a really hot topic, at least at the European level, recently due to some legislation that was introduced in November 2022, which is the DSA, or Digital Services Act. And this is basically intended to harmonize some of the inconsistencies across EU member states that we saw with implementation of the e-commerce directive, and specifically around things like notice and takedown. So it's considered a bit of an upgrade on the existing exceptions for intermediary liability.
Yeah, that's right. So that's at the EU level. Of course, it's not implemented in the UK because of Brexit, but we're obviously keeping a close eye on what's happening in Europe. And I suppose we also should mention intermediary injunctions in this context. So even when a service provider has the protection of one of these safe harbours, it can still be susceptible to injunctive relief. We've done lots of work in this area, and our work has primarily been focused on what we call website blocking orders. So these are orders that require internet service providers to implement measures to restrict access to websites that are infringing copyright or trademarks, as the case may be. These sorts of injunctions have much wider implications though, so they could be applied to other online intermediaries whose services are being used by third parties to infringe copyright or trademarks. So this is very much a developing area of law as technologies also develop, and one that we're very much engaged in and excited to see what the next developments are.
Well, thank you, Rachel. This was a super fun conversation, and if anyone would like any more information about this or other topics, please do check out the Wigan website.